Economic Freedom Fighters leader Julius Malema remains defiant and says he'll challenge his conviction in the firearm discharge trial. Addressing supporters in East London in the Eastern Cape, Malema announced plans to approach the Supreme Court of Appeal immediately after his sentencing on the 23rd of January next year. The East London Magistrate Court found him guilty on 5 counts under the Firearms Control Act. The charges stem from a 2018 incident during the EFF's 5th anniversary rally at the Sisa Dukashe Stadium in Mdantsane.
Comrades, you must not be deterred. We live here highly determined. We are going to fight this up until the Constitutional Court. We are coming on the 23rd of January for sentencing, and after sentencing, we will immediately put an appeal so that we can go to the higher court because we think a judgment is faulty. The strategy has always been you must try to charge Malema with everything. One day, maybe we'll find a racist judge who will find him guilty, whether he's guilty or not. Because they said accused number 2 gave me the firearm. Now they are releasing him, which means he didn't give me the firearm. Why are you not releasing me when you release a person you allege gave me the firearm? By releasing accused number 2, the whole case should have collapsed. But the racist was looking for me, and that's why they could not collapse the case for racist reason, to appease the AfriForum, to appease the Oval Office of Donald Trump, to appease all the white supremacists of South Africa who want to undermine the dignity and the struggle of black people. So fighters, we should not be discouraged. We should continue to fight, because this fight will not end today. We are going to the appeal, and we will go to the Supreme Court. We'll end up at the Constitutional Court. We are not fighting the case. We are fighting racism, pure racism that we have been subjected to for 7 years. Mediocrity of the highest order.
Now joining us for analysis on the Malema firearm judgment is legal expert Ulrich Roux. Good afternoon, Ulrich. Thank you very much for joining us on Point. Firstly, your reaction to that judgment.
Good day. Thank you for having me. Well, certainly the magistrate was at pains to go through all of the evidence that was led during the trial. She recapped the evidence over a period of 2.5 days. And I think she did this in order to, confirm that she had evaluated all of the evidence led, and for possible appeal to follow, to show that all factors had been taken into account. Mm-hmm. I think when one looks at her judgment, she found Julius Malema to not be a credible witness. She found him to have evaded perfectly straightforward questions. For instance, he was asked how many times did he fire off the firearm, and who fired it off if it wasn't him, and his answer was it must have been by the hand of God that the firearm went off, which is really not a good answer strategically if his aim was to come across as being a credible witness before court. Mm-hmm. She also found that the ballistics expert who had evaluated the firearm and looked at the video evidence was credible, and that his findings were to be believed, and that he withstood cross-examination in this regard. Mm-hmm. That is the only objective of a presiding officer, is to evaluate the evidence presented, to determine whether the evidence was credible, and to determine whether the witness withstood cross-examination, and then to make an objective ruling based on that. So I think if one has regard to all of the factors that she mentioned in her judgment, that it was the right judgment that was made. Mm-hmm. Unfortunately for Julius, his evidence was not credible, and it was accordingly rejected by the court.
Then to the impact that such a judgment could have on Malema's continued participation in Parliament. He's yet, of course, to be sentenced, but as per the Constitution, we know that a sentence of more than 12 months without the option of a fine precludes one from taking up a seat in Parliament. So what would be the minimum sentence that such a charge would carry?
Well, this offence that he has been convicted of, so the reckless handling of a firearm, the unlawful discharging of a firearm, and because it is a semi-automatic firearm, means that it falls within the ambit of the Minimum Sentences Act, which prescribes that if a person is convicted of such an offence, they could face a minimum sentence of 15 years imprisonment, and he should, if he is able to show substantial and compelling circumstances during his sentencing, then that could force the court to deviate from this minimum sentence which is applicable. So the starting point in terms of sentencing for him in this matter is 15 years imprisonment.
Sure, so that already excludes
most certainly, yes, most certainly he is looking at a period of imprisonment of more than 12 months. And if indeed that is the case, then that would preclude him from being a member of parliament, as you correctly pointed out. Now, in order to determine what a reasonable sentence would be, the magistrate is going to have to take a number of factors into consideration. Firstly, it is the seriousness of the offence. So in other words, were people's lives placed in danger as a result of Julius Malema's unlawful handling and discharging of that firearm? What was the purpose of him firing off this firearm? What were the surrounding circumstances? Then secondly, his personal circumstances will be taken into account. So in other words, has he previously been accused or convicted of similar offences? Has he previously been implicated in violent firearm-related offences and behaviour? What are his personal circumstances in terms of his dependence on him? What are his contributions towards society, etc.? That will all be placed on record. And then thirdly, the interests of society need to be taken into account. When sentencing Julius Malema, the court must ensure that it is a just and a reasonable sentence, but that it carries the necessary deterring weight in order to prevent people from committing similar offences going forward. So in other words, what message is sent by the sentence to society?
Now, Ulrich, we've heard him...
These three factors...
Yeah, you can continue?
These three factors are then taken together and considered, and are blended with a measure of mercy in order to determine what is a reasonable and a just sentence. So certainly, some strategic decisions that need to be made by Julius Malema and his legal team. The factor of whether he clearly shows remorse for his actions will also be taken into account. And him making statements that he made immediately after having been convicted to his supporters will certainly not count in his favor. He says that he was convicted purely as a result of a racist magistrate. But it is that same magistrate who still needs to sentence him. So certainly, he needs to make some decisions going forward
but would
on whether he will be able to...
Pardon me for interjecting there, but would utterances outside of the court space really matter in this instance, or it can be taken by the NPA to say this is an individual who has not shown remorse, but gone on to label this as a racist incident?
Most definitely. So during sentencing, Julius Malema will be presenting evidence in mitigation of sentence. So in other words, trying to convince the court to hand him a lesser sentence, whereas the state will be adducing evidence in aggravation of sentence. And this speech that he made to his supporters will most definitely be placed on record by the state to show that this person, immediately after being convicted, goes out and proclaims that the magistrate clearly made an error, that she's purely racist, and that he should not have been convicted. Now, that is, in my view, not a person who shows remorse whatsoever. And he will have to be careful going forward of any statements that he makes in the public domain prior to sentencing.
Now, speaking of going forward, he's indicated in that address to his supporters that he'll actually be appealing this specific judgment. What are the prospects of success, specifically in the Supreme Court of Appeal?
Well, so after sentencing is handed down, he will then be able to file an application for leave to appeal. He can either appeal only the conviction or only the sentence, or both. If he only feels that the sentence was too harsh, he could decide just to appeal that in an attempt to avoid incarceration as a sentence. But it's difficult to tell now, what the prospects of success of an appeal would be, one would first have to look at their grounds of appeal and why they say that the magistrate made an error in law in convicting him. Most certainly, his testimony will be focused on during any appeal process, and the appeal court is bound by the record in the court of first instance. In other words, all of the evidence that was led during this trial in the East London Magistrates Court will form part of a record which will be placed before the appeal court. And as I pointed out earlier, his testimony where he provided evasive answers and he was found not to be a credible witness is certainly going to count against him going forward in any appeal court as well. But one would first have to wait and see what their legal grounds are for taking the matter on appeal, and would then be able to make an assumption on the grounds of success or the probability of success of that appeal.
All right, Ulrich, thank you very much for your analysis this afternoon.